Thank you so much, Mr. Rao, and thanks everyone for taking time out to join this session. Today's session is on drafting effective contracts from a vendor and supplier's perspective. So essentially, we'll look at the key aspects of a valid contract. We'll look at the major issues that a vendor or a supplier has to consider while signing up. A lot of times, especially for small and medium enterprises, as a vendor or supplier of goods and services, we are not in a position of strength and therefore are oftentimes made to sign up to clauses which we are either not fully comfortable with or don't necessarily completely understand the implications of. The purpose of this session is to give you a slightly broader perspective of what the implications of some of those provisions could be. Contract drafting and its execution and implementation has changed over the years. Now with emails and other electronic means of communication, there are lots of electronic contracts that we are all signing up to without necessarily even reading up on a daily basis. Every time we accept the terms and conditions while buying a ticket or buying any goods and services online, we are essentially entering into a contract and signing up to the terms and conditions therein. So my colleague and the head of legal operations in Lexplosion, Mr. Christopher Maroharan, has prepared this presentation with support from one of our lawyer colleagues, Mr. Aditya Saraswat. So Christopher and Aditya will take you through the various aspects of contract drafting and its implications. And the session will be approximately for an hour, after which we'll be very happy to take any questions that you may have. So over to you, Christopher. Thank you for taking the session.
Thank you, Anthony. So we're going to go through a very interesting topic. The topic is effective contracts from a vendor and supplier's perspective. So basically, let us first understand what a contract is. A contract has several ingredients. First of all, we have an offer. Then there has to be legal capacity for the person who's making the offer. There has to be acceptance, and there has to be a consideration associated with it. And if all these four things fall into place, an agreement is created. We're talking about legal capacity. It means the legal capacities of both the parties that are entering into the contract. It could mean an individual, or in case of a company, it would mean the authorized representative of the company. In case of an individual, a person who is required to have legal capacity is a person who should be above 18 years of age and who should be of a sound mind. In case of a company, the person who is representing the company should be a person who has a valid power of attorney from the company to be able to enter into the contract. So if all these things fall into place, we have an agreement. How is an agreement different from a contract? An agreement which is enforceable by law gives rise to a contract. You can't have an agreement between two people for doing something that is unenforceable by law, or doing something that is illegal. For example, to set up a gambling joint within the territory of India. So that would be an invalid contract. Although it is a valid agreement, it is unenforceable, so it does not amount to a contract. What are the important concepts in a contract? So important concepts are proposal, offer. There should be an intent or willingness to do or abstain from doing something and to obtain assent from the other party. So when one is making a proposal or one is making an offer, there should be a clear willingness to do or abstain from doing something. Say for example, there is a road that is running between two properties. From the main road, there is one apartment A and apartment B, and the owners of apartment A, which is close to the main road, for security reasons, want to build a wall behind their apartment, which will effectively block access to the owners of apartment B. The owners of apartment B have an issue with this. They approach the owners of apartment A and they tell the owners not to construct that wall because it will stop access to their property. So both the parties agree to this. So the owners of property A say, yes, we will abstain from constructing this wall. So that is a consideration for the abstaining from doing something is a consideration, and with that they obtain the assent of the other party. So abstaining from doing something can also be a method of finalizing the contract. A proposal in words, written or spoken, are considered as express proposals or offer. So sometimes all proposals need not be written. Some proposals can also be in words. Even if they are in words, they can still be considered as express proposals in certain cases. I would like to refer to this particular case, which is IBP Co. versus Ramashish Prasad Singh, where an oral agreement about grant of dealership given by a person who had no authority to do so was held not to be a promise nor a proposal. So please understand, if it was an oral assurance about grant of dealership, which was given by a person who had authority, then it could have been a promise or a proposal. The fact that the person did not have authority to do so rendered the promise or proposal ineffective. So this is something we need to keep in mind. Offer versus invitation to trade. So this is basically the difference between an offer and invitation to offer. Now we have two types of ingredients to a contract here. If one is seeing an advertisement to buy, say, jewels at a 20% discount in a jewelry shop. Now that advertisement is not an offer. It's not an offer to go and buy jewels in that jewelry shop. That advertisement is only an invitation to offer. So once you see that advertisement and you go to the jewelry shop in pursuance of seeing that advertisement, pursuant to which you're going to get a 20% discount on your making charges, and you offer to buy those jewels, that is when you're actually making an offer. So that offer is later on accepted by the jeweler, and you pay and the consideration is paid, and the contract is finalized. So we need to see this. We need to understand the subtle difference between an offer and an invitation to offer. I'd also like to bring before you a case which was followed by the Supreme Court, and that case is written down there. So here, the plaintiff offered to purchase a lodge owned by the defendants for rupees 6,000. He wrote to the defendant's agents asking whether his offer had been accepted, and saying that he was prepared to accept any higher price if found reasonable. The agent replied, "Won't accept less than rupees 10,000. The plaintiff accepted this and brought a suit for specific performance. It was held that the defendant did not make any offer or counter-offer in his capability, but was merely inviting offers. There was no assent to the plaintiff's offer to buy at rupees 10,000, and therefore no concluded contract." So you need to understand what the agent said was, he said he won't accept less than rupees 10,000. He did not say that he will accept rupees 10,000. So this is a key differentiation, and this key differentiation made the difference between an offer and a concrete offer and an offer which was not very specific. So an offer has to be specific, has to be to the point, to be able to be accepted by the other party. In case the offer is not specific or not to the point, then the offer falls. What is a promise? When the other party accepts a proposal, it becomes a promise. Consideration. Consideration can be both monetary and non-monetary. So you can have a situation where one party agrees to give consideration in the form of cash So that is a monetary consideration. There could also be another situation where a party agrees to do or not do a certain thing, which can also be consideration. What are the essentials of a valid contract? The essentials of a valid contract are: number one, there should be free consent. The two parties which are entering into the contract should not be coerced or forced in any way. There should be free consent between the parties. There should be both the parties should be competent to contract, and both the parties, that is the signatories to the contract, should have the authority or the competency to sign on behalf of the company. The party that is signing the contract should not be a party that is not competent to sign for the contract to be valid. The consideration must be lawful. So you cannot be saying that you will be paying in packets of narcotics or ammunition. The consideration must be actually lawful for the contract to be valid. The object should be a lawful object. The object should be not to, as I said, build a casino, a gambling casino, or any other unlawful object, but it should be for a lawful reason. The contract should not be declared. The contract can be declared as void in certain cases. Say, for example, if there's a contract where both the parties agree to provide for to have 20 child laborers in a factory for 3 months, that is clearly clearly illegal and is prohibited under the Child Labor Regulation and Abolition Act. So, hence, this contract will not be valid. Basic clauses to draft a contract. What are the basic clauses? So first of all, you have the preamble to the contract. The preamble to the contract identifies the parties to the agreement. You have two parties. Sometimes it could be a tripartite, or even there could be 4 parties to the agreement, or even more than that. There could be multiple parties. It has the date of the agreement. It has the place of formation and the address of place of business of the contracting parties. All the parties intended to be bound by the legal status, place of business, and third-party beneficiary. All the parties have a certain legal status, that is, status in terms of whether the person is a service provider, the person is a recipient of services, and all those aspects are mentioned in the contract. The place of business, the address is mentioned, and there can be a third party beneficiary in certain cases. You have a title to the contract. It could be a retailership agreement, it could be a contract to provide services, it could be a mergers and acquisition agreement. So that is the title to the contract. What are the recitals? The recitals are declarative statements but not binding provisions. They provide the basic text, structure, and context of the transaction. So when you're looking at the recitals, you get a good picture of what this contract is going to be about, who are the parties to the contract, what are they seeking to do under the contract, what are the various actions they're seeking to perform under the contract, and what are the considerations they're seeking to pay under the contract, and how is the contract going to come to an end. So this provides a basic, it gives you a bird's overview of what a contract is going to look like. What are the basic clauses to draft a contract? So you have the contract, the contract definition. This definition of the contract, it defines the terms that appear in different parts of the agreement. Why do you have to define terms which appear in different parts of the agreement? This is because when you have a particular term which is appearing repeatedly in different parts of the agreement, we all know that that particular term has a specific meaning, and that meaning can be seen in the definition. Suppose there is any dispute as to whether a certain term has a different meaning, then one can go to the definition and understand what the particular term actually means by going to the definition clause. So that is why it is very important to have terms which are going to appear repeatedly and which are important to the contract. It is very important for those terms to be defined. And what is the subject matter of the contract? The subject matter of the contract It provides structure of the transaction. It broadly defines the scope, the method of payment, the time of completion, and the main matter of the contract. So basically, the contract will need to have the scope. You'll have to mention what is important in the contract, what does the contract cover, what the contract does not cover, what is in scope, what is out of scope. So you could have a situation, for example, when you have, say, for example, you are providing building services, and you are in the business of construction. So if you're also saying that you are in the business of getting the building materials to the site, for getting your laborers to the site, for constructing the property, well, and if you're saying that all of that is a part of your contract, then all of that is going to be in scope. If you're going to say that certain aspects of the contract, like transportation, that is getting your building materials from outside to the site, is not something that you're going to consider for the purposes of construction of the house, but that is something that is going to be done by a third-party service provider, then that is outside the scope of the contract. So you will have to clearly state what is in scope and what is out of scope. What are the key commercial clauses you find in the agreement? The key commercial clauses you'll find in the agreement are: number one, confidentiality terms. Confidentiality, why is it important? Now, when there is a transfer of intellectual property from one party to another, or this transfer of any kind of proprietary information from one party to the other, then the party that is actually transferring the information is going to be very careful, or going to be uh, very cautious about the intellectual property that it is giving to the other party. So there are going to be terms around the manner in which that intellectual property is going to be used by the receiving party. And there are going to be terms which are going to state how much of that property, intellectual property, can be disseminated to a third party, and if it can be disseminated to a third party, under what conditions it can be disseminated to a third party. There are also going to be exceptions in that clause, which basically state that if there is any information which is obtained from the public domain, or any information that is obtained from a third party without any restrictions that are mentioned in the contract, or any other information that is given in under any other valid contract, then the information that is received under these exceptions could be information that does not fall under confidentiality and are not bound by the terms of this confidentiality provision. So exception clauses need to be very carefully drafted out. If you want to give any exceptions, the kind of information you want to share needs to be very clearly defined. The kind of information you want to be sent to a third party needs to be very clearly defined. So all of that needs to be very clearly captured under the confidentiality terms. The indemnity and risk allocation provisions, these basically flow from the conditions and warranties clause. So you have the conditions clause and the warranties clause, which basically capture, sometimes we call it representations and warranties instead of conditions and warranties. It basically means the same. And the conditions are the basic parts of the contract, which are crucial to the completion of the contract, crucial to the completion of work under the contract. So if the conditions are not completed, or if the conditions are breached, then the services under that contract are considered as incomplete. So it is very important to ensure that the conditions are completed. In case the warranties are breached, or you're not able to carry out your warranties to the extent that is mentioned, then it could result in damages. The work would have been completed, but the work would not have been completed in a manner that the recipient desires. To that extent, the service provider is going to be liable for damages. So although it might not really be a breach of the contract, it could still result in damages. So the various methods in which this breach is addressed is one of which is indemnity. So the provision on indemnity is normally invoked when there is either a breach of a condition or a breach of a warranty, where the aggrieved party wants to be held harmless. What is a contract of indemnity? A contract of indemnity is a contract where one party holds the other party harmless from any loss that the other party suffers pursuant to an act that the first party did under the contract. So, if party B can show that the party B has incurred a loss or a damage which is directly flowing from an act of party A, and if there is an indemnity provision which makes party B eligible to claim indemnity, then party B can go under this clause and claim indemnity under the agreement. So there are a few things that we need to understand when we talk about indemnity. Number one, when you're giving indemnity, you need to be sure that you are covered by a contract of insurance. That is, you cannot give an indemnity if you're a service provider and you say that you're going to indemnify another party, say for $2 million, then you cannot be agreeing to indemnify that other party for $2 million unless you have a backup insurance policy of $2 million. So you need to ensure that you have enough of coverage or enough of insurance to be able to take on that kind of a risk. Secondly, you also need to ensure that your revenues have been factored for in such a way that if you're giving an indemnity of $2 million and the situation arises, you also, you also have a contract which is big enough to justify that kind of a risk that you're taking. You cannot be entering into a contract of say $10,000 and be willing to give an indemnity of $2 million. It is completely disproportionate. So you should be able to factor your risk accordingly and accordingly make your payouts. What is limitation of liability? Again, limitation of liability is a very important part of any contract. You need to limit your liability, especially in commercial contracts. Without limiting your liability, you could be exposed to unlimited liability. And this unlimited liability could be liability that can extend to both not just direct damages but also indirect damages. When we talk about direct damages, what are we talking about? We're talking about loss to property, we're talking about personal injury, we're talking about infringement of intellectual property, we're talking about any kind of damage to proprietary rights. So all of this are direct damages which could directly impact the business. So these kinds of damages need to be limited. So if you are earning a revenue of say $2 billion in a year under a particular contract, then you will need to limit your liability at least to that much, if not more. So at times, however, the service provider is not willing to, the service recipient is not willing to agree to a limitation of liability that is so huge. He doesn't want a limitation of liability ideally. He would like to have zero limitation of liability. He would like to have, he would like to have the service provider taking on all the liabilities. But then that is where negotiation comes in, and both the parties agree, if not for 100% liability, they agree to limit it to say 50% or 25% of the total value of the contract. So again, this is a very commercial negotiation that takes place depending on the facts and circumstances of each case and the negotiating power of the parties. So normally we tend to limit our liability for direct damages. In very rare instances, we also tend to limit our liability in indirect damages. Indirect damages, as you all know, are damages with respect to loss of opportunity, damages with respect to loss of data, and damages with respect to certain losses that you can't foresee at a given point in time. So those are indirect damages. So normally we try to exclude all indirect damages because these indirect damages are not foreseeable at the time that you're entering into the contract. But then sometimes the parties negotiate. The service recipient sometimes insists on treating aspects like loss of data as direct damages, something that he can foresee, and they might ask for a limitation on that. So So again, most of this depends on the facts and circumstances of each case. Intellectual property rights. Intellectual property rights, again, a very crucial clause in commercial contracts. Property rights span all kinds of on contracts where there could be transfer of intellectual property. These are mostly in software contracts, but could also be in uh, large engineering procurement contracts. It could be in large acquisition contracts. It could be in large infrastructure contracts where there is a transfer of intellectual property rights from one party to the other. So here there are few things that we need to keep in mind while we are entering into a clause on intellectual property. Number one, we need to be sure about the intellectual property that we are either owning or transferring under the contract. So if there is intellectual property that one party has, which he is transferring to the other party, then he needs to understand, he needs to know whether this particular intellectual property is being completely transferred, being licensed, or is being assigned. If it is being licensed, then is it a license that is going to be a limited license, or is it going to be a license that is going to be a little more extensive? Assignment, as you all know, is a complete transfer of the intellectual property to the other party. So if an assignment is done, then it is very difficult to revoke the assignment unless you have a clause somewhere in the agreement which says that the assignment is revocable. But this is something that the courts normally do not allow because an assignment is considered as a transfer. If you're doing a license of intellectual property rights, you need to decide whether the intellectual properties that you're going to give is going to be exclusive intellectual property or a non-exclusive one. If it is going to be intellectual property that is going to be royalty free, is going to be worldwide, is going to be an intellectual property that can be free transferred. So all these are rights which you decide when you are dealing with intellectual property. So you have worldwide rights, you have royalty free rights, you have irrevocable rights. So when you're giving intellectual property, you need to decide whether those rights are going to be revocable or irrevocable, whether they're going to be worldwide or geographic specific. Are they going to be royalty paid or royalty free? So these are various aspects you need to decide when you are actually transferring intellectual property rights. Now we come to the key legal clauses in an agreement. So we've dealt with the commercial clauses. We're now coming to the legal clauses. Legal clauses, governing law and jurisdiction is an important clause, especially in cross-border contracts where the parties normally negotiate on the jurisdiction which is most favorable to that particular party. So you could have a contract between India and the United States of America where the governing law could be the laws of England, and the jurisdiction could be the jurisdiction of English courts. So it doesn't necessarily have to go by where the where the services are being provided, or where the parties stay. It can be completely at the agreement of the parties. However, if it is a domestic contract, a contract where both the parties are in India and services are being rendered out of India, then the jurisdiction necessarily has to be that of Indian courts, and the law has to necessarily be that of India, because you cannot oust the jurisdiction of the Indian courts. So the Indian Contract Act specifically prohibits the ousting of the jurisdiction of Indian courts. The contract normally has a dispute resolution mechanism as well. So if you're going for litigation, you have only one source of having your dispute resolved, and that is in the courts. So you have to present your case before the courts and follow the mechanism involved in having your dispute resolved before the courts, and that could be long-winded and convoluted at times, which is why most parties now agree to go for alternate dispute resolution. So under alternate dispute resolution, you have different methods of going in for alternate dispute resolution. You have mediation, conciliation, negotiation, and arbitration. While mediation, conciliation, negotiation, or also effective forms of dispute resolution, the arbitration continues to be the preferred method of dispute resolution, if not for any reason. It is for the reason that the order that is given pursuant to arbitration proceedings can be enforced like the order of a court of law, like the order of any court. We now come to restrictive covenants. So we find these restrictive covenants also in many of our contracts. These restrictive covenants could be covenants relating to non-solicit, non-compete, and non-hire. We'll be dealing with non-solicit and non-hire initially, and then go on to non-compete. Non-solicit is basically entered into in two different situations. One could be a situation where an employee enters into a non-solicit or a non-hire clause with his employer, stating that after his employment is over, that is after the termination of his period of employment, he will neither solicit or hire any employees of the previous employer at any time for a period of say 6 months after he separated from his parent company. There is also a non-compete provision which parties enter into, where you have an employee who is separated, who gives an undertaking to the to his parent employer, or the employer with whom his preceding employer rather, that he will not compete with he will not be providing services for another employer in the same line of business as his previous employer for a period of 6 months, for a certain period after he is separated from his previous employer. So this is a cooling off period. So in all these cases, the employee is restrained from either soliciting or hiring the employees of his previous company, or competing with his previous company in any form for a particular period. This can in a flurry of cases, both at the Supreme Court as well as in the High Court level, in many cases, it has been decided that any kind of non-solicit or non-compete can only be during the term of the contract. If it proceeds beyond the term of the contract, in cases of non-compete, it can be accepted for certain reasons. However, for non-solicit and non-hire, it is completely illegal to have a non-solicit or non-hire clause for which extends beyond the term of the contract in any case. In case of non-compete, there could still be a situation where the court might agree to to allow the person not to compete if the person has all the intellectual property of the company, and allowing him to compete is going to cause grave damage to the company. In such cases, the employer may not be allowed to compete. But otherwise, it is always only up to the term of the agreement. There could be another situation also where these clauses are used. These are used between two parties which are entering into a contract. So if you have a service provider and you have a service recipient, and both these parties have this non-solicit clause, where the service recipient agrees not to solicit, the service recipient agrees not to solicit or hire the employees of the service provider at any time during the term of the contract and for a certain period of time thereafter. So this is between two independent parties, and this, although it extends beyond the term of the contract, this has been upheld by the courts in many cases, because this is not between a superior party and a party which is not as superior as a company, but these are between two independent parties which are equally strong as far as the commercial aspect of it goes. So this is as regards to companies that are entering into non-solicit and non-hire provisions. Companies can also enter into non-compete provisions, where the service provider is asked by the service recipient not to be providing services to another party which is of a similar nature as that is being provided to the service recipient. So if there's party A and party B, and party A is a service recipient and party B is a service provider, party A tells party B not to provide similar services to party C because party A is afraid, party A is worried that some of its intellectual property might be passed on to party C. So there could be a non-compete provision in that case as well, where both party A and party B say that during the term of the contract and for a period of 6 months or 1 year or sometimes even more, both the parties, party B will not compete with party A by providing services to any other party during the term of the contract and for a fixed period thereafter. So these are the various provisions that you will normally see as regards restrictive covenants in various contracts, and these covenants, as I've said, have been dealt with by the highest courts of the land from time to time. Commercial terms. We know that the commercial terms in a contract are very important. Among them are the price and payment terms, the invoice requirements, the billing schedule, the payment schedule, and the currency. So this is the commercial part of the contract. We need to very clearly mention what the price terms are, that is the invoice, that is by what time will the invoice be paid. If the invoice is not paid within a particular time, will there be a period of interest that is running? And if so, what will be that interest? Will it be a reasonable interest? How often will the invoices be raised? And in what currency? Please note that if it is a domestic agreement, you cannot have a currency other than Indian currency. So you will need to take care of this every time you enter into a contract. The tax provisions are also laid out in the contract, and the tax provisions clearly state as to who is going to pay which component of the tax. If a contract is between a service recipient and a service provider, the invoice value is normally inclusive of taxes except income tax. So that is how normally services agreement for services are structured. However, there could also be situations where the invoice value excludes all taxes, and taxes need to be factored for by the service recipient. There are productivity terms mentioned. So this is basically related to certain aspects of, suppose the outcome of the contract is better than expected or is in a manner that both the parties are very happy with, then there is a certain proportion of that outcome which is either shared between both the parties or is discounted from the invoice value. So in other words, the service provider will be giving a discount in case the service that has been provided is so profitable. The service provider will give a discount, and over a period of time this amount will get apportioned towards him over the years. You have a service level agreement and SLA credits. So SLA credits is a situation where you have two parties which are entering into a service level agreement, and and whenever there is one party which is doing well in the contract, so whenever there's a party that is doing well, that is whenever the service provider is doing well in the contract, he is been able to do his work very well. He's been able to reach the targets that are that he's supposed to be getting, that he's supposed to be reaching. Then there are certain credits. There are certain credits that are apportioned to the service provider for reaching those targets. So this credits could either be in the form of money, or it could be in some other form. It could be in the form of revenue sharing, which the service provider is entitled to at a later point in time. There are also certain aspects. There is also something called SLA debits. So when both the parties are not entering to when both the parties enter into service level agreements and they are not able to reach the SLAs that have been set out, the service recipient rather has not been able to reach the SLAs that have been set out for him, then the amount gets debited from his account. So if he is entitled to an amount of say $1 million every year and he is not able to for some reason reach his targets, and instead of getting that $1 million, he will only be getting $0.9 million because he has not been able to reach his SLA SLA agreement. We now come to the technical clauses in the agreement. Data protection is a very important part of the contract. Data protection is a clause which we normally have in contracts which are entered into between two parties where there's a lot of data that flows from one party to the other. This could normally be in contracts where there are these call centers which are involving a lot of which are handling a lot of private data, personal data of people. So here you have clauses which basically state that number one, the information that is provided to the data subject is information that is given with the consent of the party whose data that to whom that data belongs to. Number two, the information that is given is information that will not be passed on to anybody else without there being a contract which has in force terms which are as stringent as a contract that has been entered into between both the initial parties. So both these aspects need to be taken care of before both the parties agree to have data protection, the data protection clause. Business continuity plan. Business continuity plan is now a very sought after clause because in many cases when there can be man-made or natural disasters, the parties want to ensure that they're able to continue to receive services because some of these services could be very critical and could be and not providing these services could result in the complete collapse of their business. So here you have a clause where one party, that is the service provider, agrees to have another alternate venue from where he'll be able to provide services in case there is a disruption in the services being provided to the service recipient because of man-made or natural reasons. So here what normally happens is both parties agree that there will be a venue in a country other than the country where the services are being provided, which will act as a backup venue. This could be a third party, and this will help ensure that there is continuity in services being provided. Technology updation is another important clause where both the parties agree to ensure that any technology that the service recipient is being benefited with is completely upgraded and he is able to get the latest technology. Disaster recovery plan. So if a business continuity plan is something that you have to put in place immediately as soon as a disaster strikes, a disaster recovery plan is the plan that needs to come into force as and when there is a man-made or an artificial or a natural disaster where you are able to salvage what is there or whatever has been damaged in the main place where the services are being performed. So if there is some way in which the damage can be mitigated, the damage can be lessened, if something can be salvaged from there, what needs to be done immediately to be able to salvage whatever can be salvaged, so that the main business place, that is if we're talking about country A and country B, and country A is where the disaster has taken place, what needs to be done in country A to ensure that the business is up and running in country A is the disaster recovery plan. The delivery of goods and services, we've already spoken about it. but just to dwell on it a little further, delivery of goods or services. This is normally done, as we've already said, through a contract. Now, what are the different forms of contract? Forms of contract could be contracts on which could be a normal letter of engagement, could be uh, forms of contract could be a normal letter of engagement of purchase. It could also be a purchase order, and it could also be any kind of a written agreement between two parties, terms and conditions, which is actually signed. So, if between two parties, one party gets a purchase order, which also has the terms and conditions on it, although the purchase order could look like an offer because it is only an order and it's not been accepted. The fact that there are terms and conditions attached to that purchase order, and the fact that you're signing on the purchase order and the other party is also signing, makes that purchase order a contract. Similarly, a letter of engagement, although you might just call it letter of engagement, the moment you sign it, it is a contract. A memorandum of understanding is the same thing. Once you sign it, it becomes enforceable, just like a contract. So it doesn't matter what you call a contract. You could call it MOU or XYZ, but insofar as you agree in writing to have your terms captured there and signed by both the parties, then it is a valid contract. So the other significant terms in the contract are to develop contract exit strategy. A contract exit strategy is very important for every contract. So when we're talking about a contract exit strategy, we're talking about the various termination provisions that you normally have in a contract. This could be termination provisions which have a termination for convenience clause, a termination for uh, terminating for cause. So you have a termination for terminating for convenience and a clause for terminating for cause. In a termination for cause, you normally have a clause which basically states that the agreement will get terminated for cause in the event of the arising of the following reasons. And you've already defined cause somewhere to state that cause means the following. Cause means that one party is not able to complete its services within a particular point in time. Cause means that the party has breached its conditions, which are mentioned in a clause dash. The cause means that the party has failed uh, to uh, complete this portion of the contract, XYZ. So basically, cause could mean so many things. So the moment a situation arises where one party can terminate for cause, then that party can give a 3-month notice to that other party to terminate the contract. I'm just giving it over to my colleague Aditya, who will proceed further from here.
So in developing contract exit strategies, what happens is there is another clause which is termination for convenience. So out here we are talking about vendors, service providers. So what happens if a particular service provider is giving a service or developing a product for ₹100, and later on there is some technology updation due to which that product by somebody else can be prepared in 80 rupees. So this is a convenience for this person who is taking the services. So out here, for a small vendor, for a service provider, as a contract strategy, what they need to do is they need to avoid the situation where there is a clause for termination for convenience. Because whenever they see that they can get the services for lesser amount, they will always terminate your contract for convenience. Now, insurance related terms. So as we spoke about, there is from representations and warranties, indemnity clause flows, and as you need to indemnify the other party, so what you, to minimize your risk, you put a limitation of liability, which is you are capping your liability there. So now how do you cap your liability? So even if you cap your liability for rupees, for example, for rupees 5 lakhs, you need to have that 5 lakhs from somewhere. So to avoid that situation, what you need to do is you go for an insurance term where you take an insurance which will help you in paying those limitations, the liability cap. Now, in a lot of services, what happens is there are many players. So there is an audit term as well. So where the person who is taking the services or the company which is taking the services can go and audit the service provider. So this is again a tricky situation. Can the person who is taking the services go any point of time and do audit at the service provider's premises? The answer would be no, because it will cause trouble. So in an audit terms, they decide when they need to give a prior notice to the other party that there will be an audit. So these are some of the terms which are significant. And then negotiation. The entire contract process itself is a negotiation. So from your preamble to your termination clauses, from payment terms, everything, both the parties have to sit together and negotiate. And it's very important that both the parties understand the contract in the similar manner, because if there is any doubt, it might cause a dispute in future. So these are some of the other significant terms which is important in a vendor agreement. Now, I'll take you to the conclusion. So it is very critical to have a consensus ad idiom to avoid future confusion. So this entire drafting of a contract, negotiation between both the parties. So both the parties should be very clear what is required in a contract. Because if there are any doubts, or if any one party is trying to hide certain things from the other, it is a cause for potential dispute in future. So both the parties should lay down all their clauses and should explain it to the other party. Next is identify your organization's risk and the appetite. So we have spoken about indemnity, we spoke about limitation of liability, insurance. So every vendor, service provider should know how much of a risk that organization can take. Accordingly, they should go for insurance. Accordingly, they should cap their liability. Accordingly, they should indemnify. Because what happens if today a cell phone manufacturer, if that cell phone manufacturer says, I will give you the cell phone, but there is no warranty in it. So nobody will buy that particular product. So you need to take that risk, and for that you need to have an appetite. So accordingly, you need to decide how much appetite you have, how much risk you can take. Now, there are certain items in a contract which are non-negotiable for a vendor or a service provider, such as an open liability clause. There is no limit. So especially for small vendors, service providers, it's very important to have a limit on the liability. Otherwise, if there is any claim, the small vendors, service providers might have to shut their shop. So there are certain clauses which are non-negotiable. Then for vendors and service providers, it's very important that their key stakeholders within the organization know the strategy. And by knowing the strategy, I mean they know what are the terms that are non-negotiable, how much risk that company can take, what is the appetite, are both the parties in consensus with the terms of the contract. So we see there are a salesperson who go on behalf of the vendor, so they cannot commit something that the organization cannot provide. So it's very important to have your key stakeholders to know what is the strategy on contracts for your organization. So this is all about with respect to and I'd like to give the mic to Christopher.
So thank you, Aditya. So I think we've come to the end of this presentation. Thank you for listening to us, and Mr. Rao, if you're there, we'll be happy to take questions.